Hey, this is Justin Bathen, and this is the module on instructional issues, on issues of Kentucky school law. So this is a fun module. Let's just jump right into it. All right, so at the root of this module is this question of who has control over the school curriculum, this thing that kids are experiencing every single day in schools. It takes up the vast majority of the time that we spend in schools. So the curriculum itself, legally, who controls that? And so the answer to that, not surprisingly, if you keep the legal framework module in mind, is that the state has ultimate control over the school curriculum. All right, so the state can legislatively say, we want you to follow these set of standards, and they do, of course, the Kentucky core standards, or any state can set out any similar policy about these are the things we want you to cover from a curriculum standpoint. They can put in specific provisions like you will celebrate this holiday. Kazimierz Pulaski is a classic example of a Polish holiday that we want celebrated in schools. So they define how many days the kids will go to school, all this stuff about the curriculum and the instructional program is set out by states. Now, for us in Kentucky, we have sort of our foundational policy that came out of CARA 158.645, 6451 being, of course, my favorite statute, the one that followed that talks about what the goal of schools is supposed to be. But then we have a whole bunch of administrative regulations that give us more guidance about how to do our curriculum. We have the Kentucky Department of Education publishing program of studies documents, core contents for assessment, documents academic expectations. Oh my gosh, it is massive. And a lot of that is being defined by the state. And of course, we'll talk about the testing program in a second and what the legality of student testing. And all of that sort of gets wrapped up in this big topic of instructional issues. And the state, the legislature, as then delegated to the Kentucky Department of Education, has sort of ultimate control over everything that goes on from an instructional standpoint. Now, they do choose to not talk about certain things. Those things then get passed down to local school boards to, in their discretion, decide what's going to go on at a local level. Then from the local level, they can pass down to school site-based decision-making councils that can make some choices about sort of the pedagogical approaches that are going to happen in a given school relative to the state standards and the district priorities. So there are layers here of who's controlling the school curriculum. But at the end of the day, legally, if the state legislature says this is going to be our curricular policy, that is going to be the curricular policy. And if they want to define pedagogical approaches, they can do that too. So all of that, I think, raises the question of what of academic freedom? Is this a thing that teachers possess? And we'll talk more about this in the teacher rights module when we talk about teacher expression. But really, when it comes to the curriculum and instruction, teachers have no real concept of academic freedom. That doesn't really exist. What does exist is sort of the play in the joints of the law, in that the state is not covering every single moment of every single day. The district is not covering every single moment of every single day. And so within those sort of legal spaces, teachers get to make lots of choices about what are we going to cover today, how are we going to cover it, how am I going to make my pedagogical choices, what kind of work are the students going to do, what kind of assignments should the students make, how are they going to turn that in, how am I going to grade it. So you can see that teachers are making a really huge swath of choices here, but that's simply because the state is permitting them to make those choices. If the state wanted to define even more in a fine-grained way, they could. And you see some districts adopting textbook policies. For instance, here, Fayette County recently adopted some new textbooks. And the district, of course, has the authority to do that, and teachers are then expected to follow along. Now, SBDMs here in Kentucky play a role, and SBDMs at the local site level can push back against district policies at times, and they can also help set some curricular and some pedagogical choices. So it's a real balancing, but at the end of the day, teachers sort of have few rights other than those that exist that just simply are not defined. Okay, now let's get into some small areas of instructional issues. One of the things that we'll talk about more when we are together in class is issues around instructional choices that boards want to make, and the classic sort of case here being around evolution in biology, which is such a controversial topic in society. It has been for a very long time, even going back to the Scopes monkey trial that happened in Tennessee now a century ago, deciding whether or not schools can teach evolution or creationism. And there have been recent iterations on that, and we'll talk about that more in class. Ultimately, boards do have a lot of authority here. As you'll see in the Dover, Pennsylvania case, though, what must be taught is science. And of course, we've decided that intelligent design and creationism is not science. This also comes up a lot when we talk about banned books. A local school board or a state Department of Education can set out banned books, right? And each year, this is 2011, but each year there's a new list of banned books that get published in terms of, the most popular books that get banned each year in schools. And you'd be surprised what's on that list. What offends local boards is a wide variety of things, and Harry Potter's been on that list at times in the past. Now, as long as local boards are putting out clear policies about how to make these choices around books and they're following those policies, yeah, they're allowed to make some decisions about what books are not going to be both in the school curriculum and in the school library. Another huge issue, and it's become a massive issue over the course of No Child Left Behind, now after No Child Left Behind, of course, is around student testing. And we've had a lot of cases that come out around this in whether or not compulsory student testing is legal. And we have a case, the Deborah P. case, that from the Supreme Court that gave us a lot of clarity that yes, mandatory student testing is a legal thing, and we can tie student achievement to those outcomes. Now, what the courts have said is that they need to have a rational basis when doing so, and then when they set out clear policies, they must follow those policies. So two big things are important when it comes to areas of testing and pretty much everything else in this module. Courts are extremely reluctant to get involved in instructional choices being made at the school level, but they do get involved in two cases. One is when there's not a rational basis for a policy, and that meaning like it's completely arbitrary and capricious and just a really ridiculously bad decision meant to harm kids, that the courts will find themselves involved in from time to time, but that's a very high standard. But the one where schools mess up and principals mess up far more frequently is when schools put out policies that are going to help determine the curricular program or the instructional program in a given school, but then they don't follow those policies. That really annoys courts. So, of course, we have a whole bunch of policies about our accountability system, about student testing, about appealing student testing, about opting out of student testing. So there's a ton of policy out there for you principals and teachers to follow when you are executing the instructional program of a school. There's some other things, some pictures from STEAM that fall in here. Promotion and retention. Very similar standards apply to promotion and retention, and schools are allowed to do retention even against the parents' wishes. Again, they must have clearly followed the policy, and there must be a rational basis for that retention. But again, courts are reluctant to get involved too much in these cases. Community service, mandating community service for students, that is legal. Paint your lockers, by the way, subtle hint inside of this particular slide. It is legal to require students to participate in community service, have an internship, so that external part of school can be incorporated into the instructional program. And also graduation. There's a lot of legal cases out there around graduation. It's this big event that parents want to celebrate, and they have a tendency to litigate this when you want to keep a kid from graduating. This was our first graduating class at STEAM. You can see we pull from the whole city, all the different robes. Students do not have an absolute right to participate in graduation. They do have a right to a diploma if they've met all the academic credentials at a given school. But, kids a lot of times in their senior year like to misbehave. They like to participate in senior pranks and a variety of things. And schools have a tendency to want to hold them back from graduation for these various things. the graduation program itself is not something they're entitled to, and so schools are able to hold them back from graduation. If they have done something crazy, they are not allowed to hold the diploma for those kinds of events if they have earned all the academic credentials otherwise. So that's it for instructional issues. Again, big takeaways here are you got to have a rational basis for the choices you've made around instruction. Most of the time schools do, but don't make arbitrary and capricious decisions. And then secondly, when you have policies, follow your policies. The courts get super annoyed when you said you're going to do it this way and then you wind up doing it a different way. In those cases, they will find for parents or students against the school.